Maddie, welcome to People in Legal.
Thank you, Dave. Very happy to be here.
I am loving your office here.
It's very cool, isn't it? It's like an industrial site that's been turned into a workplace.
I mean, my challenge was getting a coffee machine working. That's the only thing, but other than that, just absolutely amazing.
Awesome. Yeah, it's very cool. We love it here.
And well located as well in the middle of North Sydney.
Exactly right under the Harbour Bridge. When the train goes past, the office, you can hear it.
Don't get too many rattles and bumps and things like that at all.
Not too many rattles or bumps, but it's cool. You would have seen the cars. We've got a guitar shop. We've got an optometrist. We've got everything here, and food delivered right to your desk if you need it.
How awesome. I mean, that's it. But anyway, that's a bit of the office itself.
I'm not here to sell the office.
I'm loving it. So we've had a couple of near misses. We nearly probably got to talk at a couple of different conferences and things like that. It's fantastic to finally chat with you about yourself and about what iManage are up to as well, and what's happening in the marketplace. But let's talk about you. You've got an interesting career journey to tell. So introduce yourself to our audience.
Thank you, Dave. So my name is Madeleine Porter. I am the legal industry expert here at iManage for APAC. So relatively new role. I started in September last year, and the role is primarily focused on being a customer voice and a conduit between being a technology provider for legal services and lawyers. As we all know, lawyers speak a bit of a different language, so to be able to translate and break down any silos and communicate ideas, back and forth is essentially what the role is in a nutshell. But yeah, prior to that was a lawyer, but a risk and compliance lawyer, so working within UK-based law firms predominantly within their risk and compliance space, so conflicts, ethics, commercial advisory, helping with AML, so doing a wide range of varying tasks within that sort of risk and compliance sphere. And before that was at the Law Society of New South Wales as a solicitor in their practice support unit. So again, working with lawyers adhered to their regulatory and ethical obligations, anything related to the conduct rules or the legal profession uniform law. So got a variety of, different types of questions, anything from costs, ethics, regulatory compliance. So yeah, it's been very varied, but very much in the niche. We created a niche in helping lawyers practice law, which has sort of become my area of expertise, which is an area I really enjoy.
Yeah, so you're well tapped into the market. You're hearing about what, as you said before, you've always been in a position where you're actually supporting lawyers, you hear what they've got to say. So this is going to be a really interesting conversation around two big topics. That'll come later on.
Yes, Sam.
So what's iManage up to?
iManage is leading the charge, I think, in so many different areas. So iManage has got a suite of products from cradle to grave in terms of running a matter or running a law firm. So we have our risk and compliance products. So that's your intake, that's your AML solution, which integrates obviously with our SPM threat manager, which is all of the cybersecurity, your information barriers. We also have Work 10, which is our flagship. So that's our DMS product, which I'm sure everyone's familiar with, that integrates with Outlook. We have an amazing new product in the knowledge management sphere called Insight Plus, which is just incredible. And we go all the way through to record disposition. So we have electronic record manager, our record management solutions. We even have a legal transaction management solution called Closing Folders. And on top of all of this, we have AI. So we have AI enrichment, which is running an AI solution across your entire DMS, which allows you to categorize all of the documents within your DMS. So you can say if it's a facility agreement, if it's a employment agreement, the date, the governing jurisdiction, which is actually really important because one of the things we've learned with AI is that AI is not very good at discerning and distinguishing jurisdiction. It's one of the things it's not very good at. It's lots and lots of things, but jurisdiction distinguishment is not one of those, which is highly important and critical when you're a practicing lawyer that you get the jurisdiction correct.
Absolutely.
So to be able to sort of stamp a particular document or mark it with the right jurisdiction is really important when you then want to engage AI, generative AI over that particular document. We have Ask iManage, which is a product that I'm very close to and really excited about. That's our AI capabilities within Work 10. So that's bringing AI to your documents, but I'm sure we'll go into that in a lot more depth. And we also have AI across our knowledge management. There's so much to speak to. I think I could just spend the entire time just talking about all the products that we have, but I won't I won't do that today. But yeah, AI's got lots of amazing capabilities, co-authoring, very embedded with Microsoft. So, there's just so many new improvements coming all the time. Exciting space.
AI. Wow. Wow, what a big area from a law firm perspective. So many different applications and use cases and ways it can be used. There's that, but you've also then got as well clients of law firms that are actually using AI in their own way. They're getting products from law firms and using AI to then check those products and get advice. Talk to us about what you're actually hearing in the market about AI and what's going on there.
That's a really good question. And you're right, it's a bit of a jungle and a maze out there for lawyers to navigate. It's really difficult, particularly when you've got your ethical obligations, client commitments, client contractual duties. And you might be able to use AI with some clients. They might be more open to it than others. But the key thing is, I think, to identify and start with are the risks. You shouldn't be using, and I guess it's very risky to be using AI within platforms that sort of where you're taking a document, say it's a highly sensitive top secret document, or let's say, law firms, we've got the employer's duty to maintain the psychological safety and well-being of their staff. So just sort of drilling into sort of more granular detail, if you've got a matter that has highly distressing content, say it's to do with an abuse case, and you've got a team of lawyers where they've undergone certain training, from a well-being perspective that they are able to receive that information. They might have worked on similar matters. They've got sort of techniques in place to maintain that and ensure that they're psychologically safe when dealing with that content. But obviously, they're working lawyers. They might want to use AI to, for speed, accuracy, efficiency, and to get all of the benefits from AI from working on that matter. But if they were to take that out of, say, their safety and security of a DMS, such as iManage, where they might have the restrictions in place, it might be a matter that's behind an information barrier, so highly guarded in terms of who can access that information. And remember, for an information barrier to be effective, it has to be effective at all times, which means you can't have a moment in time when the information barrier is weak or that wall has essentially collapsed or been compromised in any way. And if you take it out of a safe and secure system and you put it into another AI platform to get the advantage of AI, that's a huge risk. Imagine if something went pear-shaped, if the wrong recipient was to receive that highly distressing content, you could have a duty of care breach on your hands, as well as a lot of different other claims against you. There's regulatory, ethical implications. You could be breaching your client contractual terms. You could be exposing yourself to a data breach and cybersecurity incidents. The consequences could be quite catastrophic. So one of the things that I particularly, as I mentioned before, that Ask iManage solution is we are bringing AI to your documents. You do not have to take them out of that safety, that security, that governance that you have in place, which is your DMS, and take it somewhere else to be able to utilize AI. You can have all of the benefits AI brought to you, to where you work, and you can do it in a safe and secure fashion, because that safety, security, confidence, that absolutely is paramount. It has to be preserved and maintained and honored at all times.
I picked up on something you said before about the psychological aspect of, that to me, that really rung some bells. Talk to me about what are law firms doing around actually, I guess, helping people work with AI and that psychological layer, like the people side of things.
In terms of, you mean using the new technology? I think law firms are the customers that we have, particularly the customers we're working with in that particular space, with myself in particular, is we have, as I said, Ask iManage. You can only get that via the Wayfinder program, which is sort of a pilot group within a law firm. And the law firms I've been working with are really carefully considering who comes on that program, giving the people on the program a lot of guidance, a lot of care, a lot of instruction. And they work with us, and we really show them and talk them through use cases, how to make sure they're getting the most out of that, out of the program. But in more general, the psychological safety, I think it varies across organizations, law firms. A lot of people perceive AI differently. I don't actually think a lot of people would be cognizant of the risks, that psychological safety element. I don't think a lot of people are even fully sort of aware that duty exists and how sort of important it is that law firms do take steps as an employer, that all employers take steps to guard and ensure that their employees are psychologically safe at work.
Yeah, that's rung bells for me when you said it. I thought to myself, I hadn't thought about that, because you think to yourself, here's AI, I can use it, I can do X, Y, and Z with it. But it's got huge capability, and the sort of stuff it can provide back to you, well, it could be very damaging.
Well, it could be damaging in many different respects as well. Just think about it. You're working on a highly sensitive matter. Say you're working on information pertaining to price sensitive information and it's behind an information barrier and you want to use AI. It's a lot of transactional work could fall under that category, and you need a lot of it would entail document review, synthesizing information, large volumes of information. So they would be a natural candidate for the benefits of AI. But if they were to take it out of the safety and security of their platform and put it into another platform, they risk, as I said, compromising that information barrier. And then if they compromise that information barrier and then that information, say, was to be exposed or the other side was to sort of somehow prove that that information barrier didn't remain intact, it's not effective according to the Australian Solicitors Conduct Rules, because it has to be effective at all times, you open yourself up to potential claim. You could be, fall foul of the Australian Solicitors Conduct Rules, ethical implications. Obviously, your clients are going to be extremely displeased. It's just that there are lots of risks that can flow on from that.
Do you think that law firms have got a duty, an obligation to educate their clients, potentially legal risks of their clients using AI?
Absolutely. I think so. I think obviously they need to explain the risks and obviously make sure that I think the main onus though is if a client is sharing information with them, the onus is on the lawyer receiving that information, how they are handling it. I guess you can sort of tell them and guide them, but you can bring a horse to water, but you can't make it drink. So you can't be there in the room sometimes with them and controlling how they are using AI. But I think it's more that you can assure that the client that you're using AI ethically, responsibly, and that if they do share a top secret information or a top secret matter or highly classified or it's highly sensitive or whatever it is, and if you say that you want to use AI obviously for more efficient, more swift legal, to be able to provide swifter legal advice, that you would be doing so ethically and ensuring that safety, security and governance at all times so that their information is not going to be exposed or is at risk in any way.
And how's AI impacting the whole knowledge management function within a firm?
We get asked that a lot. So obviously people are realizing, I think AI has sort of had a bit of an awakening within the knowledge sphere. People are realizing how important it is to make sure that your knowledge house is in order to be able to get the most out of AI. Is that old adage of rubbish in, rubbish out. So if you're feeding your AI platforms or tools redundant, obsolete, or just sort of, trash, junk information, you're going to get the output will obviously reflect that. You're not going to get the result and the output that you would like. So people are starting to realize, okay, well, if we're going to be using AI, how do we make sure that AI is being fed and we're inputting our best knowledge into our AI platform? So a lot of people are sort of wanting to use AI as part of that curation process, which is key because obviously that's time consuming. A lot of law firms don't necessarily have the resources on hand to be able to deploy that properly. So we've been working with a lot of firms and being able to use our Ask iManage solution to be able to help with that curation and even give that summary a bit, and the AI enrichment as well to be able to help find what you want. And then you can use Ask iManage to sort of run that summary over the document. And we have an amazing platform called Insight Plus, which allows you which is a knowledge library. So you can create it directly from your DMS and it goes into your knowledge library, which allows you to store your best assets, which is law firms are essentially built on knowledge. So to be able to have that collated, curated, accessible to all of your staff, it's a bit of a game changer. And on top of that, we even have something called Ask Knowledge, which allows you to run a natural language question over your knowledge library. So it's sort of the reverse of knowledge in, knowledge out. You're going to be asked, like it's that being able to have that, ask a golden question and it's going to be run over all of your golden information. So you'll get a fruitful response.
I've heard the comment about, just on the topic of knowledge management, I've heard some comments that it's underinvested in, that there's not the investment from the firm into that sort of area within a lot of law firms.
Yeah, I think it definitely, we've seen it vary across different law firms. But the thing is, I think it's ubiquitous in terms of the importance of knowledge. Knowledge is important in all areas of law. Your lawyers are sort of, you give advice based on your inbuilt expertise, the knowledge that you house within your firm. But obviously, I think it's a cost, it's the resource element as well. Not every law firm is structured the same and has that capability within it, which is fair enough. Every firm runs differently, and that's not to say that they're any worse than others, but I do think it's a really important requirement to be able to reshare and to use knowledge. It obviously is a time saving and it's an efficiency factor as well. But we know that the resource isn't there. That's why being able to use technology to be able to assist in that respect is hugely beneficial. And as I said, that AI capability, that information architecture before artificial intelligence, IA before AI, is also gaining a lot of traction because people are realizing that you actually need that. You need to be using your best information to be able to get the best information.
You've got really probably two schools of thought where you've got this centralized knowledge management.
Yes.
And then you've got decentralized knowledge management where you've got the lawyers who are working on the cases feeding into a pool of knowledge and that sort of stuff. So you've almost got this being decentralized. What are you seeing more prevalent? What are the benefits of both?
A centralized system is obviously you've got a team there that's there to support the wider lawyers. And I guess you've got a point of reference. So if a lawyer has a particular question, they've got a go-to person. They've got somebody actively, that's their job, is building, curating, sourcing knowledge to support, say, a particular practice group. So obviously you're going to have maybe a more sort of bountiful knowledge base within centralized team because you have the resource to support it. With a decentralized model, it's obviously, it can be a little bit more sort of haphazard the way it's run. You're relying on the lawyers as well submitting their knowledge, which doesn't always happen. We've seen it, it's different as it is for every person is different. Every type of lawyer is different. There are some that are more willing to share the knowledge. Others might just, forget and they just are so absorbed in studying the next matter that they don't think that the information they have from that matter would be really useful to share on, or it's just not part of the way they work on their radar. So you run the risk of great knowledge falling between the gaps because you don't have, I guess, that someone monitoring that surveillance, that oversight, as you would more likely in a centralized team.
The challenge is, as you sort of mentioned before, is a cost. Over here, you've got a profit center. You've got people actually churning fees and bringing their accounts in, working on client work, and the knowledge is a byproduct of what they're actually doing. Whereas over here, you've got a cost and things. I guess, what are your thoughts on that?
Well, yeah, absolutely. I think it depends on the firm and sort of where they feel that the value lies. So I don't think you can say one, obviously not everyone can afford to have a centralized knowledge team, but I think having some sort of way to be able to share, create and disseminate knowledge is hugely beneficial regardless of if you have a centralized team or an uncentralized or a decentralized team. So I think using technology, if you can't afford the resource, so having a tool where it's just very easy, it's almost seamless that people can easily just, shoot something off, get it, make sure that it's, someone can sanity check it, make sure that, that is the type of knowledge they want to include in their knowledge library, that it's not overrepresented or, underrepresented, that you've got sort of the very diverse knowledge bank. So using technology, I think in those is powerful for both a centralized and decentralized. But obviously in a decentralized mod, you probably could harness the power of technology even more.
I guess the fee earners over here, one of the things that is more prevalent is the career paths that these guys have got as well.
Yeah.
In a situation where you've got people working and billing, their career path is based on the billings and based on the clients they're bringing in, etc., versus tenure versus number of years.
Yeah, exactly. Like you said, all partners and professionals are different. It would be great if the career track was more. We do have like chief information and knowledge officers as a career track, but yeah, I think the incentivizing piece is really interesting. And I also think that equity model can filter down even as far down into knowledge. So you've got the traditional method was that partners or the lawyers would work an X amount of year, and after a sort of a particular period of tenure or once they got to a level of seniority, they would be made equity partner, so salary partner, equity partner. And now we're seeing that sort of eat what you kill model that's probably more prevalent overseas come into Australia, and get that sort of mindset definitely filters into knowledge because it doesn't matter how long you've been there. Got that hunger to succeed, hunger for more, obviously for more revenue, can work and make people more siloed. It can also have the opposite effect and make people more collaborative. But we have seen it also make silos very sort of stark.
One of the conversations I had one day was that the whole knowledge bank is like a future fund. It's like the silent asset that people are accumulating and putting into it. It's a big part of the value of the firm, and which lives on. And one of the comments from that conversation was, well, that's not being invested enough, and there's no career path for the people that are actually maintaining that and actually keeping that repository of knowledge. So the career options for those folks are limited.
Yeah, Well, absolutely. That's why I think being able to celebrate and I guess really recognize people that work in that space and how important they are is, very, very important because as you said, it's an investment in the future, in the future financial health of the firm. And if you compare two lawyers doing the same task, but one doing that task with a knowledge library compared to the other one that isn't using a knowledge library, it's so different. And one is sort of, very much you can have your cake and eat it too. And the other one is like just, they're going around in circles. There's a time lag. They're dependent on people, responding to them. It's just, it completely different.
How would you bonus that whole knowledge area? So if you actually had someone in that area there, how would you look at their contribution to the firm and how would you measure that and how would you bonus that?
Some firms do. Some firms say if you are a certain person that's consistently supplying really solid knowledge assets and useful knowledge assets, that's some firms recognize that as part of their bonus requirements or meeting certain targets. Absolutely. And some firms also incentivize with other sort of prizes, awards, other ways of recognizing that this person has gone out of their way to help build the knowledge.
Very interesting. I'm going to change topics for a minute now. There's 3 letters that are on everyone's tongue at the last 3 or 4 events I've actually been to. And you can guess what they are.
Oh, I would have no idea. Not AML.
Absolutely. Absolutely. Yeah. Given your background in that sort of area as well, I guess, what are you hearing in the marketplace about that? Like, it's a big change.
Oh, it's a massive change. And I always laugh when I've spoken to so many different customers at varying levels. And whenever I've spoken to, say, a few different partners and law firms, and I'll say to them, or do you know who your compliance officer is going to be? And they always say, oh, I hope it's not me. So I feel like, it's like I've been met with that response so many times where I actually think it's quite funny. I think that sort of sums up the mood
of
the room.
Don't pick me.
Please don't make it me. There's a lot of, I think, apprehension about these new changes that have come in. Yes.
How are firms preparing for it?
Firms are, I feel like, so obviously removing, say, the international firms, particularly firms that have got a UK presence, because they're running AML. They have for a long time. So they've got that inbuilt, their processes in place, and they're probably, can sit back, relax and sort of say, finally, the rest of Australia is catching up with how they've been doing things. But the Australian-based law firms, I'd say there's definitely the consistencies we're seeing across the different firms. So, as I said, a lot of apprehension, confusion. One of the main sources of confusion, I think, is around the data piece. So whenever we talk to customers about it, so often, and a lot of customers are saying, well, if we're being forced to implement this new AML CTF regime and get under the hood and look at what we're doing, where we're doing it, who we work for, all of those requirements. They're saying we might as well uplift our entire process, our entire intake process at the same time because it just makes sense rather than just picking up AML but not having a solid sort of, say, conflicts intake solution at the very beginning. And I often think of it and explain it as looking at the same coin but from two sides. So I say, well, that's a really clever approach because the first side of the coin is, they say, that initial conflicts where it's can we act? It's would we acting for client A across from client B? Would we be breaching our ethical and professional regulations? Are we going to be causing adversity to the opposing side? Are we going to is there any commercial conflicts we need to be aware of? Are there any client commitments or client contractual terms that we could potentially be breaching? So it's looking at that. Well, can we even act? What would be the sort of, I guess, ethical professional relationship impacts of taking on, say, a particular mandate or new instruction? And if that's okay, it's you turning it onto the other side of the coin. And should we act? So should we, now we know that we can. There's no ethical, professional, as I said, client commercial relationship concerns with this mandate. But the next is like, should we act? Who are we acting for? And that's when you get into, well, what exactly, who are we sort of interacting with? Who is behind our client? Where are they based? Are there any sanctions concerns? Have we got any PEPs that is sort of in this particular relationship matrix? Where are they based? We're dealing with high-risk jurisdictions. For instance, I remember working ages ago and having a mandate where there was a touch point in Iran. And it's like, well, why would we do that when we have a risk of not getting paid?
Exactly.
Our banks here won't recognize payments coming from Iran. They're classified as a sort of a blacklist jurisdiction by FATF, by the Financial Action Task Force. So why would we implicate ourselves and act, take on a mandate where we might not get compensated for it. It's that wider piece and that reputational piece. What would be the implications if we take this on? Is there going to be, if we do a simple Google search, is this something that's going to generate a lot of interest? What's our exposure level? So you're sort of asking those wider questions. And then obviously you've got to get into that client due diligence. And that's where you need that KYC, you need that data. So it's knowing at which point you need to be able to run that KYC. You need to bring in those third-party data sources because you can't run a successful AML program without verifying, without external data. You need data. It's a crucial piece of the puzzle.
I guess the competing thought or worry I've got is if I was running a law firm, I'm thinking if I'm actually working on getting a piece of work and there's a big process I've got to put in the middle here, which is, your AML process and your conflict checking, etc., and your onboarding process, will that actually put at risk winning that piece of work, or will it actually, everyone's got to do the same thing, but I guess it's a strength and speed of that process so you can move through.
Yes.
That actually, because I'm thinking myself of revenue, I'm thinking, am I going to actually lose a deal or miss out on revenue or a matter because too slow?
Absolutely. And sometimes the people who do win the work are the ones that clear conflicts first. Absolutely. There's absolutely that element. So I think having a strong tech solution in place and a process that's streamlined is key. But also, it's a little bit out of your control because depending on what current work you have, your former clients, that's every time, it depends on the facts and circumstances. So one time it might be, clear road, green lights all ahead, no conflicts, issues. But other times you might have a new piece of work where you do have things and issues and there's other stakeholders that need to be consulted, other clients that might need to be spoken to. So there are more roadblocks you've got to work through, and that will slow down conflicts. And that's something that you just can't prepare for. It's just the nature of the game, and that just depends on your sort of conflicts footprint, what you're doing and who you're working with.
Thinking on the revenue side of things, is there a place for law firms to educate their clients on the fact that there's going to be different intake processes and conflict checking and AML, etc.?
Well, they're going to it's going to have to be an ongoing conversation with their clients as well. Absolutely. So once these new changes come in, you might have been working with a client for a long time, and now you're being asked, you're going to have to ask your client, I need documentation. I need, proof of identity documents. I need company certificates. I need your copy of your company constitution, all of these supporting documentations that they wouldn't previously have not required. Now they're going to have those difficult conversations, which will be a huge changer if you've got a new client that's come in. And when we did a web webinar on this recently, I gave the example of having a young uni student waltz into your office and say, I want to buy this penthouse in Bondi. And previously you would have been like, this is great, easy work, revenue generating, simple, this is great. Now you have to stop and think, okay, so I need to know who this client is. I need to sort of verify as well all of the documentation that they've given me that is correct, that they are who they say they are. So once I'm sure that this person is that they say they're X, that they are X, then I also need to run it and see, well, what's their source of wealth? What's their source of funds? Where are they getting this money to buy that penthouse from? Are they from a really wealthy background? Are they an owner of a company? Okay, if this company structure is really complex, you get sort of maybe some spiny senses going that they purposely have made this, really, really vague. I need to sort of maybe, delve further into who is actually standing behind this company. So it's a much more drawn out process, and it's not as easy as I guess it used to be, where it's like, yep, you want to do this, I'll do it for you. You're going to have to really sort of make sure that you are fully confident that the client is who they say they are. You understand where their source of wealth is. You understand if there's any sanctions implications, if they're a politically exposed person, what jurisdictions they're coming from, they're based in, who the ultimate beneficial owner is, if there is a sort of company structure that they're related to. So it's a lot of investigating, I guess, that you're going to have to be doing now that you previously didn't have to.
It's interesting because I think to myself, the documents you're collecting for intake is almost like part of a DD set of documents for a company. So there's actually a business opportunity there as well to actually sell the value of that to the clients, and the fact you are collecting these documents, they are in a vault. You're maintaining those ones, and it's an excuse to have ongoing conversations with the clients.
Exactly. And you have to store these documents for a minimum of 7 years.
Yeah.
Well, absolutely. And law firms are going to be required to store a lot more personal sensitive information. So to be able to assure them that you're saving and that their documentation is safe, secured, confidentiality is maintained at all times. Absolutely.
So I think it's akin to accountants who have actually got their clients' general ledgers and looking after all their sort of matters like that. With with law firms, they've got this documentation and they've got an excuse to, if their clients need X, Y, Z documents they can't locate, the law firms have got them. They can go back to law firms.
Well, potentially, but you've also got to be very careful under the Privacy Act that the information you've collected and that you're storing is used for the purpose that it was collected for.
Got it.
So, I think as long as you're adhering to the Privacy Act and the Australian privacy principles, then you'll be fine.
I guess you could open that process up as well and sort of say, we've got these documents here from XYZ company. Is there other things you think are important as well we could actually throw away for you as well in a vault?
Well, potentially. I think it's more the business opportunity would be more that once you've, particularly if it's a new client, you've run the KYC, you're confident with the client. So obviously they probably don't want to go through that whole process multiple times with different law firms.
That's
so the
right.
fact that you've done it with them and they're confident, but you have to run an AML and CTF compliance over every new matter, regardless. And sometimes criminals are very clever. So sometimes they will make sure that the onboarding and that the new client stages and maybe the first few matters, they've got the green light so that the law firms or any of their tranche 2 reporting entities sort of lower their guard. And that's when the money laundering can start later down the track. So you've got to be constantly vigilant. And every new matter, obviously it depends whether it's a designated service or not, needs to be checked. And you need to make sure that you're confident that there's no money laundering risks. But yeah, it's once you've got the company who that you've run the KYC, you've identified if there's, enhanced client due diligence or any ongoing monitoring that's required, you do need to have a process where each new matter is also, you're running a process over that as well.
So how can firms forward plan for this?
Is start looking, I think, at technology, what technology they can implement to make this streamlined, efficient. They will need some form of platform to be able to manage this, particularly the larger firms. I think also looking at who their current client base is, so doing a data cleanse. So if they've got any insolvent, duplicated client entries, you can start having a mass deletion, sort of cleaning out your client base, so you're only representing your current clients, because obviously you're going to be having to run AML from 1st of July next year, so you don't want to be running that over clients that where you're not even working for them. They're, the retainer's been exterminated years ago, or they're just no longer a client, or they don't exist if they're insolvent. So that would be the first step.
And from a point of view of the cost to a firm, so I mean, if they're actually, it sounds like there's a huge cost to these guys running that process. Is that cost passed back onto the client, or are they absorbing the cost?
I think there's whichever way you prefer. I think because all law firms are going to be in the same boat, you could argue and say that, yes, that's a disbursement that you could then put back onto your client. How those costs are absorbed, I think, will vary depending on how law firms structure it and who their clients are and how they want to do it. So it's whichever way. There's no right or wrong way to do that, to structure it.
How law firms gear up on the people side of things. I mean, there's not a massive number of people in the risk and compliance area who know about AML.
I know, so they're very highly sought after. I think you'll see a lot of the law firms are sort of recruiting and looking for someone within that space, particularly someone who can act as that compliance officer. So yeah, there's definitely a shortage. And I think people that are very well versed in the space will easily be able to find a role if that's what they want to do. But I also would encourage other people. It's a great time if you were interested in particular that career path. It's a great opportunity to get upskilled, and the world's your oyster, so to speak. There's a lot of different job opportunities out there.
Like what kind of people would they be? Like what areas of law would they be practicing in?
So I guess if you're working in any type of financial regulatory role, even mergers and acquisitions or real estate, construction, I think all of those different areas where you've got the touch points would be beneficial. Obviously coming from risk and compliance, that's a bit of a no-brainer. But really, I think if you're legally qualified or or even you don't even have to be legally qualified if you've got that interest in sort of that being a little bit of a detective and understanding sort of the wider world implications, knowing how the finance of money, where it goes, where it flows, maybe putting a bit of a criminal hat on, thinking how they could sort of misuse certain channels. I think it's a very interesting space to be in. So I think lots of different, it would be sort of complement lots of different types of skill sets as well.
Maddie, I'd like to thank you very, very much for today. It's been a really informative session. I've really enjoyed and learned a lot. So thank you.
Oh, my pleasure. Thank you, Dave. Nice to be here. Thank you.